All right. I like to begin things pretty close to on time. So I'm going to start. So first of all, my name is Jordy Ayton. I want to welcome all of you here. Um, this is this is an eState Academy webinar. And for those of you who recall the Institute for Wills and Estate Education, IWE, it is now morphed into the eState Academy. So we welcome you all. And for Make a Will, we do these webinars, by the way, every Thursday at this time. And all of our eState members are welcome to attend. For Make a Will month, we decided to open it up to everybody who would want to participate. And so we thank you for joining us. These webinars are about half an hour. We try to get you in and out, and then we open up time for questions as well. So that's that. I mean, Make a Will month is the OBA's program, and trying to encourage people not only to make a will, but also the benefits of using a lawyer to make a will. And as many of us know, the marketplace is getting bigger and bigger as far as do-it-yourself wills online, and those documents are getting better and better, and their software is getting better and better. And so, it's something we've got to make sure that the OBA and others make the case for why we need professional advice. One of the classic ones, and today's webinar is basically like a part two, because this is dealing with blended families. And I posted on LinkedIn this idea, which it's the most common, very difficult situation. So that's sort of why it's so important for all of us to be aware of these issues. So what's the problem with blended families? Well, the problem is that the client is trying to benefit two groups of people, if not at exactly the same time, over a period of time. And that's really the problem, because the client has, for example, and I'm just going to share my screen to help with that. The client has, for example, two families in a sense. Here's your classic blended family. So we have James and his first wife Amanda, who have a kid. There's Jane and her first husband, who have a kid, and then there's James and Jane, who are now married and have two of their own kids. The clients, James and Jane, are going to have different needs, obligations, wants, perhaps, to benefit their own kids versus the other person's children, etc. Those are the risks. The risks involved are trying to benefit both the surviving spouse, if they're alive, and the kids from a prior relationship. So I consider a blended family basically any situation where there's a couple and either of them has a child from a prior relationship, because I think that's when there are potential risks. As estate planners in this situation, we don't have that many tools that we can use. We have, a handful of them. And the way I would want to structure this kind of meeting, where we've got a blended family, is I like to use a slide that sort of explains the different options as far as the will planning, because we've got things that we can do in the will, and then we've got things that we can do outside the will to achieve our goals. And goals, identifying those goals, are so crucial at this stage, because if the goals aren't kept in mind, then we could go off track. If the goals, for example, are, look, my only concern is my spouse, and I don't really care if my children from a prior relationship get anything, versus, look, I want to make sure that I provide for my spouse during their lifetime, but I want to make sure that my kids from a prior relationship are looked after as well when that happens. And so identifying goals is obviously the first stage. So I just wanted to call up these slides that I tend to use in pretty much in every situation, but specifically in a blended family. And, really in a will, we've got three options for a spouse. And this is if your spouse passes away, um, or you pass away and your spouse is alive. Let's talk about that, the surviving spouse scenario. You could choose to give everything to the surviving spouse with no strings. That will fulfill the goal where the only concern is the surviving spouse and you have no concerns for anyone else. Because, of course, the risk of an absolute gift is that the beneficiary can do whatever he or she wants with it, including giving it all to only their own children when they die, and nothing to the children of the other spouse. The other major way of dealing with it is, of course, a spousal trust. And it's important, I think, when we describe a spousal trust, it's because clients can get concerned when you use the term trust. They're not necessarily familiar with it. But the way I always describe it is, if you use the word "but" to describe your goal, you need a trust. So, for example, if the goal of the client was to provide for the surviving spouse, but when they died, then to give it to their kids, well, then you've just described a goal that requires a trust if you're going to achieve that. And obviously, the spousal trust is the classic planning in a blended family situation, because what it does is it provides a fund for the spouse while they're alive, and then provides for a lock, in other words, to make sure that whatever's left over goes to the beneficiaries that the client wants, rather than the beneficiaries that the surviving spouse wants, which is the risk with an absolute gift. Because, again, an absolute gift, if we gave it all to the surviving spouse, even if they had made a will, there's the possibility that the client will change their will and leave it all to only their own family members or to their beneficiaries. And we'll explore that in a few minutes. So here's our classic spousal trust, where we have the capital, whatever that might be. Maybe it's a specific amount of money. Maybe it's the entire residue. Maybe it's a portion of the residue. And that's the capital that goes into the trust. Of course, the surviving spouse is the beneficiary. And there's a trustee that is going to manage that money for the spouse and make decisions about certain withdrawals. And so what I always talk about with the client is there are certain things that we have to do for tax purposes. And that is that the surviving spouse, if we put $1 million in that capital in the trust and it generates income, that income has to go to the spouse, or the spouse has to be entitled to that income, all of it. Then you can make additional rules with how to deal with the capital. And you can make mandatory rules, like I'm going to pay out a certain amount to the spouse every year, and a minimum amount. So a floor that makes sure that the spouse gets some money, a minimum amount, whatever that might be, without having to ask the trustee for that. Or you could leave it completely to the whim and discretion of the trustee. Or you could combine them. You can limit some of the discretion to maximum amounts, or specific reasons for using the capital, or allowing discretion until a certain event happens. Like, for example, they get remarried. I can stop the capital flowing out if they get remarried. I can't stop the income flowing out. That has to go to the spouse. But the principal, the capital, I could restrict in the event of remarriage or cohabitation. So in coming up with the use of this, and then of course the big key here is this section, which says that whatever's left over in the principal when the spouse dies goes to, for example, the children of the client's children, not the spouse's children, but the client's children. And that's the benefit of a spousal trust. That's locking this in. It's locking in who the ultimate beneficiaries are, so that cannot be changed. And that's one way of providing for two groups of people, right? The surviving spouse while they're alive, and the children when both spouses are deceased. So that's the classic sort of planning that we use for spousal trusts. And And just so you know, there's going to be a bunch of questions and I'm going to address them at the end. So if I don't get to your question yet, it's just because I'm going to leave that till the very end. So that's sort of how you would go through that as an option. And I would like to cover off with the client those two options, especially. I do it in every meeting, but I especially concentrate on that in a blended family. You know, I've said before, I think that it's like you got to worry about the Cinderella situation where Cinderella's father had assets, gave everything to this evil stepmother with no strings. So the evil stepmother had complete control over the house and could cut Cinderella out. Well, that's what we don't necessarily want, or in some cases, we don't want the surviving spouse to be able to do that. And that's when a spousal trust is indicated. Think about if Cinderella's father had put that home in a spousal trust for the stepmother. At least Cinderella would know that she was getting that at the end when the stepmother died. The last sort of option, because we talked about the first option, which is the no strings option, the second option, which is this use of the spousal trust, that's often the common one. And then there's the option where you combine, and of course you can combine these. You could have some assets going some assets going into a spousal trust. The other option is you might not, clients, when you show them how a spousal trust works and that, oh, you need to have a trustee and, well, you could make the spouse the sole trustee, but then he or she could take all the money out. So it's not really that useful. But then if it's somebody else, we have to, the spouse has to go to them and ask them for money, and nobody wants that issue or whatever else. So the other sort of hybrid is to say, look, I've got enough here to treat each of those two groups. I can provide for both of them. And so I'm going to carve out an amount that's going to go to the kids off the top. Then they're separated. They've got their money. And then either give the rest of it to the surviving spouse or use a spousal trust for the rest of it, or a combination. And that works especially well because anybody who's administered a spousal trust or have seen when spousal trusts go awry, there can be these issues about how much is going to the surviving spouse. And this conflict of, because whatever's left over is going to these guys, but this person wants to take as much as they can out. And so you have a built-in conflict between the life beneficiary and the ultimate beneficiaries. And so it's not a perfect solution. That's what we definitely know. We definitely know that whatever options we have, there's not one perfect one. And so one option might be, look, I've got enough life insurance that my spouse, I don't need to give that to my spouse. So I'm going to carve that out and give that to the kids. And at least I know they got that amount. Even if the rest of the estate ends up going to someone else, at least I've got that amount. And that's a hybrid way of dealing with that. And it works especially well if you've got life insurance because it's tax-free and it can go to the kids. My advice to anyone entering into a new relationship is buy as much life insurance. If you've got kids from a prior relationship, buy as much life insurance as you can afford, because that will be a huge benefit in trying to plan for these two groups of people, the spouse and the kids. So that's the sort of the classic way of planning in the will for both sets of groups, both groups. And so what I wanted to turn to, and of course, for those of you who know about estate planner, this kind of planning is built in, and make sure that you do it properly, depending on what you do. The other option, and it's something that some of us, I don't do, but some people do, and that's called a mutual will. And I want to explain what that is and the issues with it, and then look at a couple of cases. So this Ramage case is a perfect example of a spousal, of a blended family situation. We had Alf and Ruth, and they, second marriage, they each had their two kids from a prior relationship, and they go to the lawyer, and the lawyer, you'll see what the lawyer does, But in essence, at the end of the day, they make two wills, and their wills are mirror wills. That is, they look exactly the same. Everything goes to the surviving spouse with no strings. And then it says, if my spouse is not alive when I die, in other words, I'm the second to die, it goes to the four kids equally. So not only the kids of the survivor, but the four kids. So they sign these wills. There's no reference in the wills at all to this idea that somehow they're bound not to change it. Because of course, as we know, wills are revocable. That's one of the intrinsic factors of a will, is that it is revocable, always revocable. So we have these two mirror wills, very common situation. Now, Alf dies, Ruth inherits everything, and guess what? Ruth changes her will. And she decides, you know what? Alf's kids are not that good to me anymore. They were great to me when we were alive, but now I barely speak to them. And you know what? They don't deserve this anymore. And so I'm going to leave it only to my own kids. So she dies, and guess what? Alf's kids say, this is not fair. We're getting nothing, and you inherited all this money from our dad. So the question is, was there some sort of agreement? And that's what a mutual will is. It's a contract. It's an agreement not to change their will when one of them dies. And the distinction there is, are these two wills two separate wills with no agreement? Mirror wills, yes, but no binding agreement. Or are they mutual wills? And this was some of the evidence that the court used, like what did the obituary say? And what about birthday and Christmas gifts and things like that? Well, I'm not sure that certainly prior to this case, that would not have been enough to find that there's a binding agreement between the two parties. Based on this. Now, in this case, the lawyer says, or the court says this about the lawyer, and this is something that I guess this is what we want to avoid. I'm saying Jordan Ayton, who prepared the will, did not discuss the matter with Ruth and Alf. That's what I want to avoid. He simply accepted their instructions. He asked them no questions about mutuality. And I think that's precisely the problem. When we see a blended family, if we're going to act for both of them, then it's crucial that we make it clear to them, whatever the instructions, that as to whether there's some sort and I would say avoid a mutual will, and I'll tell you why, but is there some sort of agreement here? And confirm that there's no agreement if there's no agreement. So in this case, they found there was a mutual will here. And it's really the high watermark of this mutual wills doctrine, because again, we have no evidence that they meant it. There's certainly no written evidence. There's no evidence of the lawyer. There's only circumstantial evidence about how they treated each other. And so, they sort of find what they wanted. And so that is a high watermark and should be a concern to any of us who act for both family members. Because if the clients, just to shoot to the top here, if the clients do decide that everything is going to the spouse absolute, which was exactly the instructions in this Ramage case, that is documented, that it is not a mutual will. Or if it is a mutual will, we'll talk about that. There's a better way to do it, okay? So what is the impact of a mutual will? Well, I'm just going to show you a recent case. Sorry, let me just try to do that. This is a case from last year, actually, and we're going to see more and more of these cases. This is a mutual wills case. It's the Nelson estate, and just before COVID. And this was the issue in a mutual wills case, except here's where the lawyers thought they did a good job, because they documented a mutual wills agreement. And they actually said that the will itself is subject to an agreement not to revoke the will, okay? And this identified the fact that yet, this was so clear, and yet there was a case, and I can guarantee you hundreds of thousands of dollars were spent on this case. that this is a reason not to use a mutual wills agreement, because even this idea that they've done this is not good enough. Because a mutual wills agreement, what does it do? It imposes, in essence, a constructive trust over the survivor's assets, and says that, even if you do change your will, we're going to say that you're bound to do what you were required to do under the agreement. It's in effect a trust. It's saying you get to use it during your lifetime, but you got to distribute. But when you die, it's got to be distributed to the ultimate beneficiaries that were agreed upon. Well, so what's the big problem? Well, think about it. When you draft a trust, do you ever leave out what assets are going to be governed by it? Would you ever say, well, we're not sure what assets, but whatever assets are going to be governed? No. In this case, what about assets that are acquired after the first one dies? So in Alf and Ruth, Alf dies, leaves Ruth $1 million. Ruth then takes that $1 million. She buys another property. It's now worth $2 million. Is the full amount covered by the mutual wills agreement, by the trust? What happens if Ruth inherits $1 million from her kids or from her family? Does she have to divide that with Alf's kids? So this trust, relying on this concept of a constructive trust, leaves aside the whole precision of what assets are going to be governed by it. That's one reason why mutual wills are a terrible idea, because unless they're properly documented, nobody knows exactly what assets are covered by this constructive trust. And the second thing is, when you draft a trust, do you ever just leave the whole encroachment power blank? Do you ever just not make any point about that? Well, that's in effect what's happening with a constructive trust. There's no say you could take money out for this reason or that reason or any reason. Or, well, can the survivor gift money? Can they gift it to their own kids? Can they take out, how much money can they take out for themselves? Anything? We would never draft a trust like that. And using a mutual wills agreement is basically relying on a trust that has very few terms and is quite imprecise. And that's exactly why you get these cases, even where you've documented this. Sure, she doesn't change her will, but what about the after acquired assets? What about gifts? In this case, she made a gift of $200,000, and the court had to rule whether that was a substantial gift or not. I mean, that is not what you want to set up as a lawyer, in my view, and give the client have them think that they've done what they want to do. So what's the alternative than relying on this mutual wills doctrine, which again, I would strongly recommend you don't consider, or if you consider, you reject. What you want is really, if this is the idea, if this is the concept, and you don't want to use a trust, and you got to think about why don't you want to use a trust? Because you're trying to avoid probate tax, so you don't want to divide everything 50-50, and so you want to defer some probate tax. That would not be a good idea to cause this kind of mayhem to save some probate tax. But look at the definition of domestic contract here. It is an agreement in which they agree on their respective rights and obligations under, and it says, or on death. So on death. Therefore, what you've done by making a mutual wills agreement is you've done a domestic contract under the Family Law Act. Think about it. For those of you, I don't practice family law, but I always believed that that requires independent legal advice and a disclosure of assets. Now, you might have the disclosure of assets, but do you have the independent legal advice if you're acting for both people on a mutual wills agreement? I would say no. So I think but a properly crafted domestic contract that does deal with issues like what assets are governed by this agreement, after acquired assets, increases in value of assets, only the original assets that were inherited at their current at the value at date of death. What is governed? Second of all, what can the survivor do with the money? Can they spend it? And are there going to be any restrictions? If they're, can they gift it? Are there going to be any restrictions? Can they do anything else? What can they do? So if you're going to do something like this, try to bind the two parties not to change their will so they have a common ultimate distribution, then it can't be done with a note in the will. In my view, it's not you're trying to use a simple solution for a very complicated remedy, and that would be, I think, unwise and dangerous to the clients and to yourselves. So, do not. I know some people have raised the issue that financial advisors are out there talking about blended families. Yeah, just use a mutual wills agreement. That's why lawyers are important in all this, and to try to do things, because they don't understand the implications. They haven't read all the cases, and they don't realize how many bad things can happen with a mutual wills agreement, and that it's a domestic contract. So, I think really the two options are either, and with respect, this is what I would say, either a spousal trust for the assets. So if Alpha just had his assets, and instead of giving it all to Ruth, absolutely, if he had just set up a spousal trust for that, and then said, okay, my assets are going to go to my kids when you die, and your assets are going to go to your kids, it keeps it cleaner. And if that's not good enough, if no, I want to leave everything to these, I've got everything joint, so I want it to go so we can avoid the 1.5%, but we're going to impose this trust on top of it. Well, then you need, in my view, a domestic contract. And again, in my view, you need independent legal advice on that agreement, because it is a domestic contract, and it has, and the other reason you want it is because you don't want to get sued. Because no doubt that in both those cases, the lawyer who acted for both parties would have been, if not sued, scared. So I've talked, I think, before when we talked about joint retainers, about certain reluctance of some of us to act for both spouses in a blended family situation. That is especially so in my view when you're going to start dealing with a contract and you're acting for both parties. I know we're getting close to the half hour. We will send out the PowerPoints to you, and you can feel free to use them. This is a slide, as I say, I use in every single one of my meetings, whether it's a blended family or not, because if they do choose to give everything to the spouse, I want them to understand there were other options available. Because of course, who of us hasn't heard of a story where everything goes to the surviving spouse, they remarry, then everything goes to that new spouse, and nothing ends up going to the kids. And then there's this argument, well, then everyone starts raising this mutual wills argument and everything else. And it's something that, if you didn't discuss with the client, I think I'd feel a bit concerned about that. So that brings us to 1 o'clock. This webinar it counts for 15 minutes of professionalism and 15 minutes of substantive under the Law Society's CPD credits. And obviously we didn't cover everything that you would want to talk about with blended families, but this is the key, I think, as far as options go for dealing with blended families. And so I'm just going to take a couple of minutes to see if anybody has any questions. If you could put that in our chat, and I'll just raise them rather than opening up the floor, because we do have a number of people here. So, okay. So one person asks, and I think I can just demonstrate this here. One person asks, what options how can you restrict the discretion, and what options would you consider? So here's a spousal trust that we can create, and we can limit the discretion given to a trustee. So for example, I could terminate the encroachment of capital on remarriage or cohabitation or both. The other place you would do it is where you make conditions. So you say, look, you can only encroach for a specific reason, medical care, health care. You can set the annual amount. So you can only take out 100 grand a year, or the total amount. You can only take up to, 50% of the capital during your lifetime, or you always have to have a minimum capital balance, or you only get to encroach if the surviving spouse has used up all of their other assets and now they don't have any assets. Now you can encroach. So this is a way where you can You can control the discretion. So especially important if you've got the spouse as the surviving spouse as the sole trustee. These would bind that spouse, so they couldn't just take out everything. So you can combine these conditions and use the spouse as the sole trustee, but at least then restrict that. So I hope that answers that question. We got a lot about PowerPoints, so that's fine. Those are going out. And then we just said, yeah, so Rachel just mentioned that that this wealth manager had been talking about, using, mutual wills, which again, a mutual wills are by definition, if it's a mutual will, not a mere will, but a mutual will, it is a contract. But again, as I've said before, it's rife with peril. So I hope that helps. What I'd like to do is just first of all thank all of our participants. For the rest of Make a Will month, these Thursday webinars, which we do every Thursday at 12:30, are going to be open to everyone. So if you'd like to join us, feel free. And we hope to see you again. In the meantime, I'm going to stay on for another 10 minutes or so and answer a few more questions. So if you have questions, feel free to raise them. And if you want to stick around, feel free. So tips or warnings, re-spousal trust limited to real estate. So I would prefer to do so in this situation, let's say we want to leave the country home in a spousal trust. So we would do that. We'd drag the asset in, we'd create a trust. We'd look at the termination events. So for this trust, it's going to depend on who's, maybe the trust lasts for the lifetime of the spouse. If it doesn't, then we've got to think about what's going to happen to the proceeds if it gets sold. So for example, you get to live in the house until you don't want to live there anymore. Okay, let's just say. Well, then it gets sold, and who's going to pay the expenses? So I would do a more fulsome evaluation of building out this trust. So I'd look at who's going to pay the different expenses. Is it going to be the beneficiary? Is it going to be the estate? Where's the funding going to come from? Is it going to come from the spousal trust? Is it going to come from a different trust? And the other issue is going to be, what happens to the proceeds? Because we're going to want to make sure that the proceeds are dealt with if we don't want to trigger capital gains from the date of death forward, assuming it's a principal residence, and there's all kinds of things we're going to want to look at that. So I would typically do a separate trust for the home for real estate, because I want to be more specific about it than just lumping it in with the spousal trust. I think it could be in the spousal trust. I don't think there's any reason why it couldn't be. But I prefer to use that just because I want to be more specific about real estate. See if there's anything else on here that. So I'm just going to stop sharing here for a second. If that's it, if there are no other questions, then I want to thank you all and hope to have you guys back. And we'll see you all soon, I hope. Have a great week, and we'll see you next week.